How should we be thinking about those two issues?
Well, first, good morning, everyone. I just want to say that it's good to see everybody out here, and it's good to see so many people interested in this issue. And what we have to recognize is that we are literally facing an existential threat to everything that has been built up over time, and yet the power that this administration is wielding right now, many times in an illegal fashion, has not been codified, has not been sanctioned by the legislature. They aren't passing new laws. And so it's important to make a few distinctions to look at what they're doing. When you really look at what they're doing and you really look behind what they're doing, there are several groups that have been basically arguing in conservative circles that effectively they need to repeal the Civil Rights Acts of 1964, 1968, 1965, 1991. And obviously, they don't have the votes, even with control of both the House and the Senate, to do that. And so what they've tried to do is to issue executive orders which effectively abrogate the ability of the federal government to pursue any type of remedies under any of the laws that have been passed. So they have basically taken the Equal Employment Opportunity Commission, which was created under the 64 Civil Rights Act, and they've basically redirected that toward discrimination against white people, or what they call so-called reverse discrimination. And they've issued a number of executive orders, and I just want to talk about a few of those. The first day that this new administration took office, they signed an executive order ending illegal DEI. They did not define what DEI is. DEI, of course, means diversity, equity, and inclusion. And DEI is really an employment law concept. It's really a corporate rubric that was used to begin to allow companies to work with some of the issues that came about by various racial and ethnic groups, and various new roles that women and other people who have been disfavored in the marketplace were taking, and some of the friction that was causing them to face more and more equal opportunity lawsuits, and to try to deal with that. And of course, most of these diversity, equity, and inclusion programs, as we classically think of them, were in the private sector. And of course, the federal DBE program is a creation of Congress. It was passed by Congress, signed by the president. It was affirmed by the Supreme Court in Fully Love versus Klutchnik. It was reaffirmed by the Supreme Court with certain modifications in Adoran versus Pena. There are a number of other cases like that that have reaffirmed the standard, which Colette was referring to, the standard of what it takes to have these types of programs. So the law has been relatively static in this area, but of course, we know that there is a more conservative Supreme Court since the death of Ruth Bader Ginsburg, and now there's a 6-3 conservative majority on the Supreme Court that has been willing to operate in ways that have not traditionally been the way we've operated. But I think it's important to recognize that many of these executive orders are designed to get as close to not implementing the kinds of things that we have historically recognized as federal law when it comes to civil rights as possible. So one of these executive orders, ending illegal DEI, has all of these provisions in it saying that no one who receives federal funds can have a DEI program, but they don't define DEI. And a number of courts have ruled that this executive order is unconstitutionally vague because they don't describe what DEI is. But what they've done is they're using that. They've also repealed Executive Order 11246, which was put in place by President Lyndon Johnson, requiring that all federal contractors take affirmative steps to ameliorate the effects of past discrimination, and they needed to post a notification in all their job offerings saying we're an equal opportunity employer. That comes from 11246. They couldn't operate segregated facilities. They repealed that on the first day. So Executive Order 11246, which had been in place since President Johnson signed it, was repealed. And then they passed another executive order a few weeks later, which basically is designed to try to end what's called the disparate impact test. And without getting into details about that, it is a powerful tool that's used legally to make a determination as to whether or not there's discrimination in the marketplace and discrimination against individuals in employment. And of course, the courts have begun to roll that back in the late 1980s, and most people aren't aware of this, but with pressure from the NAACP, Jesse Jackson was at the forefront of this with his organization, a number of other organizations. In 1991, there was a new Civil Rights Act that was passed, which codifies the disparate impact test. But they signed an executive order saying that the federal government could no longer use the disparate impact test, even though that is in fact part of the Civil Rights Act of 1991. And so when it comes to the DBE program, what they're basically trying to do is to roll it back as far as they can, even though they don't have a legislative mandate to do it. They're doing it through executive orders. And of course, the Mid-America Milling case is important. And it's important in our estimation because once your organization, AMAC, and the National Association of Minority Contractors, NAMAC, and the Women's Business Council and a number of other plaintiffs were able to get accepted as interveners in that case, then a couple of days later, the Trump administration began a settlement process to basically say, we agree with the plaintiffs. And in agreeing with the plaintiffs in that case, they cited a case that was decided by the Supreme Court a couple of years ago called Students for Fair Admissions that has to do with diversity in education. And so what they tried to do was to say that this decision of the Supreme Court means that the Supreme Court has said that diversity programs are illegal and therefore the DBE program is illegal. That's not what the Supreme Court said. In fact, in Justice Roberts' opinion, he specifically cites the Croson opinion and says that a non-discrimination program with a factual predicate is in fact still good law. And so they are distorting what the law is and trying to pressure people into ending their DBE programs, their MWB programs at the local level, and they're trying to do this by intimidating governments. And I think I need to say one more point. What they're trying to do is intimidate governments by sending out letters threatening the withholding of federal funds. If you are in violation of the presidential executive order ending, quote, illegal DEI, we will withhold your federal funds. Oh, and by the way, if you don't sign an affidavit saying that you no longer have an illegal DEI program, you will not receive your federal funds. And if you sign it and we come in and investigate you and determine that you do have an illegal DEI program, then you can either be prosecuted by the Justice Department under the False Claims Act, or a plaintiff can bring a suit against you claiming that you operate an illegal DEI program even though you have said that you don't. But DEI, as they talk about it, has not been defined. Now, I met with an attorney who's been working in this area for many years, who heads up the government affairs section of a AmLaw 100 firm, one of the largest firms in the country. We met for 2.5 hours a couple of weeks ago to discuss what he's advising his clients. I've met with county attorneys and city attorneys. I've got about 30 clients around the country. I've talked to county attorneys and city attorneys in about 10 different jurisdictions. And our advice consistently has been that they have not properly defined what DEI is, and therefore it is unconstitutionally vague, and there's no basis for this requirement for you to receive your federal funds. That's number one. Number two, that your minority and women business program or your disadvantaged business enterprise program pursuant to the federal law cannot, by its nature, be an illegal DEI program. And these are two separate things, but they're trying to conflate these things to force you into a position where you will accept what they want you to do without them having the legal authority to do it. And so what we're saying is, make them come to the table. And I met with the county attorney of, city county attorney of a major area, metropolitan area, with a consolidated government relatively recently, who takes the exact same posture that we're taking. There are also a few states that have passed anti-DEI laws. And we did an analysis of that, of all those state laws, and the same defect is in all those state laws. And so we believe, and we are saying, and I'm saying to all of you all, that what's critical is what AMAC is doing. And finally, I just want to wrap up this one soliloquy by saying that it's really important for you all to recognize that as business owners, concessionaires, architecture, engineering firms, construction firms, program managers, that you all are the business people who have benefited from the programs, but you're also leaders. And it's very important for you to support these elected officials. Elected officials cannot stand up to the federal government unless they know they got somebody behind them. Okay? You see yourself as a business person, but you're also a leader in your community. You're the people at the community chest come to every year and say, hey, I need a check. The people at the local chambers come to and say, I need a check. The people who need your help. And right now, your elected officials need you to support them. I use the analogy of Herman Russell, who, when in my city of Atlanta, you know, black people couldn't sit in a hotel like this downtown. Matter of fact, you couldn't even go in a hotel like this downtown. And as students from the Atlanta University Center were arrested by the hundreds, Herman Russell put up his resources, his property, as bail bond money to get them out of jail. He supported Dr. King. He gave money to SCLC. You all have to follow in that same tradition as business owners. I'm speaking to the business owners in this crowd, because these elected officials have to have support, because they're trying to put pressure on you to buckle in to their illegal actions where they're going beyond what the law has ever said. And the Supreme Court, make them rule it. Make them say that discrimination is okay. The same way they had to ultimately say, no, separate but equal is not okay. Make them say discrimination is okay. We got to push them. We cannot roll over, and we cannot lean down.
Thank you, Rodney. That's super helpful. Where do we go from here? What are some other potential approaches, responses? You've talked a little bit about engaging with your elected officials. I think you're talking a little bit at the federal level, certainly at the municipal level as well. What are some other approaches or responses in addition to that, or any further thoughts on that topic?
Well, first let me say I completely agree with Rodney in terms of the legal analysis. It seems very clear to me that the courts are trying to change the standards. We have very, very conservative federal judges now who basically are taking the position, we're done with all that. And that's actually, and this is, I think Rodney and I mostly agree on this, that's really how I read the Students for Fair Admissions case. And I know there was some happy talk out there for a while of, well, it's just higher ed, it's not going to spread. Nah. The total framework that the court is using now is to say that you have to justify your program, justify what you do, and meet these very, very high tests. One of the things, to sort of just go back to the fair admissions case, that's particularly, to me, discouraging about it, is that, in fact, both universities put on full trial records that had all of the disparity study type information. It's not like this record was thin. That's just not true. And they talked about their long history of discrimination against minority students and what they had done. And I mean, if you have nothing else to do with your life, I suggest you read especially the Harvard briefs. And the court just sort of dismissed all that. And so I think that we need to be very clear about what the courts are doing. But I also think that we need to recognize that at the end of the day, this is all about political power. And that's what it's always been about. It's about money and who gets it and how they get it. And so to echo Rodney, as business people, you do have some power there. But I also think that we've got to get realistic, because as a business person myself, that's great. I mean, I'm a true practicing lawyer. That's fine, Ms. Holt, go talk to the court. But in the meantime, I got employees to pay and bills to pay and a family to support. That's nice while you go and try your cases. So I think one of the things that we need to really start to focus on is these types of quote unquote small business approaches. And I talked about this yesterday with Ken Middleton from Jacksonville, who I think is in here somewhere. There he is. He's waving his arm. And he's been way ahead of the curve. He and I have been talking about this for a long time because it was obvious that this is where things were going. So things like doing small business set-asides. This may be more law than anybody wants to learn this morning, but it is important to understand that the federal courts apply a very low standard to programs on the basis of business size, location, veteran status. And so, in fact, you don't need disparity studies or anything like that to have some type of small local business program. So certainly my advice to clients is take a look at what you think you can do there. And there are two tracks to this. One is adopting any new remedies or program elements that are small business based. You're going to have to figure out things like who's eligible for your program. Do you want a size limit that's the same as the SBA? Maybe. I like that because it's easy, it's quick, and you can tell people where you got it. Otherwise, you're making it up. And making up things makes me anxious. So you need a size limit of some kind. I personally am adamant that you have a personal net worth test in your program. I've been looking at a few states. I was in Orlando last week. 99.8% of the firms in Florida qualify as small under the small business standards. 99.6% of the firms in Illinois qualify, and it's above 98% for every single state. So that alone doesn't help you because it's everybody basically. So I certainly urge you to have a personal net worth test. You can think about whether you want to use what's in the DBE program. Does that seem appropriate for you, your community? And again, at least you can tell people where you got it from. One caveat about that, I think, though, is that it is actually pretty low for business people, and especially for airport work, especially for big airport projects. You cannot be broke and do airport work. That does not work. So you may want to think about that. Maybe you want a micro business component to your program, but these are all things that you're going to have to work through. Location-based programs are not subject to the same high constitutional level of review. Same thing with veteran status. One of the things I think is really interesting about some of these executive orders, Rodney, and I don't know if you agree with this, is that many of them exempt veterans programs, despite the fact that we have zero evidence that having an honorable discharge from the United States Armed Forces is a business barrier. But it's political, folks. I mean, I think that's disturbing to people. It's certainly disturbing to me that really this is all about politics. You know, they pulled this term out, DEI. I remember the first time I heard it, I thought, what is that? And I'm still not sure what it is. But I know what it is not. It is not a remedial civil rights program designed to address the continuing effects of systemic, historic race and sex discrimination. It's not that. So it's like CRT, critical race theory. I mean, you know, most people couldn't tell you what that was. That is a graduate level concept. And yet they figured out how to get these little phrases out there that gets all these people all exercised that have nothing to do with anything. But here we are. So think through small business elements. The other track about a small business race neutral approach is what can you as an agency do better? Historically, to be honest, we, meaning government type people, have looked at prime contractors and pointed our fingers at them and told them, you go fix it. You go deal with these little firms. You go fund them. You go deal with the fact that their certified payrolls are a mess, or their invoicing is wrong, or they need all this support. That's not going to work anymore. And it's a whole lot harder to look at your own behavior than it is to point your finger at somebody else and tell them to change. So, are you paying on time? That is the single most important thing that you can do, is make sure that you are paying your firms on time. And that includes, by the way, change orders and contract closeout. Some agencies take months, or some who will remain unnamed, take years to process change orders. That's something you control. That's got nothing to do with anybody else. And as I said yesterday, it's not sexy to add 2 more positions into the comptroller's office so that these payments get processed. But if you are a business owner, that's what you care about. Things like solicitation requirements. Really need to build 10 of these to do the 11th? What about insurance? Now, airports are tricky because you screw up out there and it's a really big problem. So I'm not too sure what you can do, except what about owner-controlled insurance policies? I see some of my Austin folks. When they built Austin Bergstrom Airport 25 years ago, it was a very innovative approach then. They had a ROSIP, and it really helped. Those are things you can do. So you have to do those things. And then I think the other thing to think through is for ACDBEs and DBEs, how do you support each other? If you know someone that you think is a good business person, and maybe you could figure out a way to work together, we got to get past this crabs in a barrel thing, people. Oh, I got mine, and we don't want Rodney to get his. You know, we can't afford to do that anymore. So what can, this is really a thing for AMAC, is what can AMAC do to help support you in that endeavor? You've met people here, follow up with them. And you got to do it early, because by the time the solicitation hits the street, it's too late. You can't get the paperwork together, the lawyers can't make it happen. So think these things through and be proactive about your own situations. And then I want to speak for a minute to the larger prime firms, because especially for airport work, it's going to be a long time before we have any minority or women firms that can bond a $500 million airport job. It's going to be a while, and I'm really hoping it happens in my lifetime. And so to the large firms, I want to say, ask yourselves, what in addition can we do to help our small firm partners? Just because there's not a goal on the project anymore doesn't mean you should stop doing what you're doing in terms of your outreach. If they were good partners before, they're still good partners. Now, it will give you the opportunity not to have to be bothered with the people that don't have their act together. Let's be honest about that. But really continue your commitment to what you are doing, because this is how you create economic opportunity in your own communities. If you've got a great sub, don't drop them just because there's no goal. And for one thing, if you do, somebody might call me and I'm a little interested. Did you fire them because they were black now? So keep that in mind. But I would suggest to you that you take a look at all of your documents And if they sound and smell like whatever illegal DEI is, and actually there's more to that phrase, I know, as Rodney knows, it's actually illegal DEI that violates our nation's civil rights laws, whatever that is. You better not be doing stuff that violates our nation's civil rights laws, because if you are, you need to cut it out tomorrow. So really, think through how you can support your DBEs and ACDBEs. And then one last point, well, and then I'm happy to turn over to Rodney, about these assurances and what people are signing. It is absolutely a pressure campaign, no question. But what concerns me is smaller jurisdictions that don't have the resources to fight the federal government. And so we have seen some situations already where in order to sign the assurances, because the mayor or whoever signs becomes personally at risk, that they have dropped their local MWBE programs to comply. I don't understand what the federal interest could possibly be in somebody else's money, but I do understand the risk. And so at least be cognizant that it is really a threat to folks. I can't wait to try that first case about, did you have an illegal DEI program, and under the False Claims Act, no less. But I do think it's important that you backstop, as Rodney said, your local officials about this, because they really are under it's a real threat, folks. It is. Easy for me to go to a meeting and say, sure, no problem, sign it. You don't have an illegal DEI program that violates this nation's civil rights laws, but I'm not the one who's going to be at risk. And lawyers, by and large, not these two, I think, but are incredibly risk averse. We are the Chicken Littles of the world. That's our whole mindset, is what can go wrong and how to keep you out of trouble. So at least be sensitive to that when your agency or your community is under this kind of threat.
Thank you so much, Colette. We're going to go to the audience for a couple of questions. Over here in the corner is a mic. Please raise your hand. While that's being handed out, I did want to just hit on the point Colette mentioned, the PNW. Today's environment of cost of capital, what we used to be able to build out for $500 to $700 a square foot is fully 3 times that now, $1,500 a square foot and greater. So to have a $1.2, $1.6 million PNW when it takes you $2.5 million to build out a little coffee shop is kind of an inconsistent dynamic. So I wanted to personally address that, how challenged how that imbalance happens. Farad?
Yeah, thank you. Thank you, Rodney and Colette, for your trailblazing years of doing this work. Y'all been doing it at least 20 years.
Oh, Farad, you're
I
so
know,
nice, a
I
lot
know.
longer than 20. Thank you, yes.
I know, I just wanted to give you the compliments. It's interesting because your generation were more like trailblazers, and y'all have done great work, and our generation we're more like settlers, right? We're building up, and we're watching it being torn down by bulldozers. And some of the skill sets that y'all have, we didn't build those, right? We kind of built on the back of the basis of what you gave us. And so we're hearing all this information of, this is illegal, you can't do that, you're threatening, you need to fight. And so we've got all these people in the audience that are here because we're concerned or fearful, or we got families to feed. And so now we go back to our cities or our airports or our authorities, and we're hearing all this great information, and we're going to try to give this back to them. And they're going to say, well, show me something, right? Because that's what they're going to do. Where is it memorialized? Is there any place that you know we can go to, or you could share with us some talking points on what you've said? Nothing to put them in a place, but to say, hey, what we've learned today is that you're hearing this, but based on CRF 11, he's creating just something to kind of give back to them to slow the roll until we can get people to get on board of this effort, because some of this fear is creating a fast pace to go hard. And if we can be advocates, say, well, just slow your roll a little bit so that we can kind of get the right information to get to the right outcome. So that's all I'm asking.
Am I really allowed to talk how I really talk?
Yeah, one of the things that we're working with several groups. Colette is aware and that the minority Business Enterprise Legal Defense and Education Fund and Democracy Forward filed the objection to the proposed uh, consent or settlement that the federal government proposed to the court in the Mid-America Milling case. And we've been, I was just on a panel with Brooke Minchell, who's the attorney there, and I was just had a long conversation with Sarah Vonderlip, who's the attorney from Beldev, and they did a great job of laying the details out, but in the objection, they filed what I thought was a brilliant document, had several conversations with other attorneys about it, feel like they really laid everything out. And what we had a conversation about doing is taking and converting a lot of that information into a general guidance that can be issued so that people can understand in more simple terms, what is going on. One of the things that I sent out yesterday, I actually sent it out on Sunday to every major organization in Atlanta that I was familiar with, and every national organization that I have a relationship with, was an article that was in the New York Times Magazine this past week by Hannah Nicole Jones, who in layperson's terms, in everyday language, lays out exactly what the threat to the civil rights laws is and what exactly this administration is doing. I felt like, she explained it in a way, and as a journalist, not a lawyer, it's very accessible. And so I've sent that out to a number of people. It can be found in the New York Times Magazine. It's Hannah Nicole Jones' most recent article about the civil rights laws. I can't remember the exact title of it. And they also, Colette mentioned a couple of things. She talked about basically having alternative types of programs. Because what's happening is, in some jurisdictions, and she's correct, in some jurisdictions, some of my clients are saying, we're afraid to keep running our race conscious local program because our county executive or our mayor would have to sign this particular attestation. And their lawyers are saying that that would be possibly run afoul of the federal administration's anti-DEI, anti-illegal DEI executive order. And we're saying, no, it's not. But they're saying, well, they're not prepared to sign it because of the repercussions of it. And so what we're emphasizing to we've drafted a number of legislation for a number of jurisdictions. And what we always put in there is a severability clause. And so in some cases, we had one client, Palm Beach County, Florida. I mentioned them publicly because it's been in the newspaper. Their attorneys basically said, we're not going to recommend that our clients sign anything agreeing to that they don't have illegal DEI as long as you have a race conscious program, even though there's a basis for their race conscious program. And so they repealed their race conscious program. But they didn't repeal their whole law. They just repealed the race conscious elements of their program. Third thing I want to say is this. We did a project a few years ago, two projects actually, for living cities, where we worked with 5 major cities: Chicago, Charlotte, Milwaukee, Memphis, and Los Angeles. And we developed a procurement inclusion guide. And it has a number of elements to it. It has a number of race neutral, is the term is used, race neutral elements. And then it looked at the race conscious elements and has a chart in it, has other information about how you can develop a program that deals with a lot of the things that Colette talked about. I'm not going to get into that. But we have both of those guides posted on our website, which is gspclaw.com, gspclaw.com, under resources. And we're going to be posting the guidance that I'm referring to when we develop it. And we're not going to be developing it independently just through my firm, but in consultation with Democracy Forward, the Minority Business Enterprise Legal Defense and Education Fund, other attorneys that you might be familiar with, like Franklin Lee, who used to be general counsel for the Minority Business Legal Defense Fund, and several other attorneys from AmLaw 100 firms that we've been working with closely on these issues that have given us pro bono time. And so we'll be getting something out as soon as possible.
Yeah, let me add one other thing to that. And I definitely think that kind of guidance will be useful. In the interim, you can always, excuse me, for Rod and anybody else, you can always point people towards the actual decisions that so far have been issued in the challenges to the DEI executive orders. So that at least you can point to something that a federal judge has said, and that may give other lawyers a little bit more backbone about it, as opposed to, just the fact that we think you shouldn't do it. But that's at least, I think, another place that you can go.
We'll definitely gather Colette and Rodney's best practices. I wanted to try to close it out by talking about what we've prepared as a little bit of a call to action. Hopefully you all have, the bell has rung, and you understand that this is an extinction level type of activity, and your AMAC wants to help you, help yourself, help us collectively move forward. And we've developed an outline of an integrated plan. Greg Willis from Phoenix Strategies, if you could stand up, he's our lobbyist in DC, has been helpful in that regard. We will get the tools from Rodney and Colette, but Rodney mentioned legal support. Support AMAC. Invest in AMAC so AMAC can financially support MBLDEV. MBLDEV's representing us. So your resources into AMAC allows AMAC to continue to support the people that are supporting us. Political support. Many of you went to the PAC breakfast. You heard Congressman Troy Carter, who I thought was phenomenal, wanting to advocate on our behalf. So participate politically with our PAC. Now is the time, as Rodney said, to write the check. Engage with your own elected officials. Inform them of the situation. Don't assume that they know what's happening. Plan some time to meet with them in district. Your AMAC has invested in a new technology tool called Quorum. You've probably seen them with other organizations where you go in and you put your zip code and it preloads a templated letter that you can send to your elected official in 2 minutes. That's going to be available. We'll write the templates, we'll get the factoids, we'll help build the fact sheets. It'll have a whole series of information, kind of move to this notion of the role and contribution that small businesses play in airports, and that what we're calling the multiplier effect. Local dollars, local economies, local taxes, and the value that local companies and small businesses have. So engage with your federal elected officials online and offline. And then last but not least, we talked about giving some thought about how the program is going to evolve. Don't assume that it's going to be the same. And so things around small business, a little broader, race and gender neutral, I think we have to be prepared to think about those implications as we go forward. So that's a little bit of the playbook. We'll package all of that up. It'll be on AMAC's website. Reach out to AMAC to get your toolkit. Set up your in-market conversation. That has to happen with your federally elected officials, but also your municipal leaders. As you know, most airports are run by cities, which are run by councils and commissions. So if you're not meeting with your council people, you're missing the boat. And so hopefully the bell is rung. You understand what existential crisis means, and this catapults us all to do a little bit more. And last but not least, you all are here. Please continue to support AMAC. And we want to thank Rodney and Colette for their years of leadership on this topic. And I think we ended just right on time. So thank you all very much.